what the F did the United States Supreme Court just do? They issued a ruling staying lower court orders that would block Donald Trump's executive orders regarding the 2026 election. Donald Trump's executive order had three components to it. One involved a voter list that the Trump regime would be sending to states. The other involved a revamping, I believe in a very corrupt way, of how mail ballots are handled at the state level to be imposed by the federal government. And the other part of Trump's executive order includes instructions to the Department of Justice to contemplate certain prosecutions or investigations against local officials for violating election laws as Donald Trump deems that to be the case. And so the lower courts, a federal court and a circuit court, said that the Trump executive order is unlawful. And then Donald Trump appealed this to the United States Supreme Court. And one of the main arguments that the Trump regime made is that the issue was not judiciable at this point and that there was no standing to sue the Trump regime yet. You see, the lawsuits to block Trump's executive order came from the states, and the states said, we are injured as a result of this executive order. Those three components that I just outlined infringe upon state rights. States control their local elections, their state elections, and the states were the prevailing party in the lower court and in the circuit court, the federal court and the circuit court. And the Trump regime said, you don't have standing yet. The issues aren't judiciable because the final rulemaking, the final orders that were instructed by the executive order have not gone into effect yet. And until the rule becomes an official rule, it's too early to sue. So the Trump regime made their appeal on that ground. And on this procedural technicality, the United States Supreme Court agreed with the Trump regime, stayed the lower court orders, which blocked the executive order. The Supreme Court didn't say they agree with Donald Trump that the executive order is a valid executive order or that what's implemented after the executive order will be valid. What the Supreme Court basically said is that it's premature at this specific moment for the states to have filed their lawsuit because the final rulemaking regarding the mail-in ballots, the final rulemaking regarding the voter list has not taken place. Once the Trump regime finalizes it, then you can file your lawsuit. Well, we do have some news there as well. As it relates to the mail ballot component of all of this and how the Trump regime wants to have their own federal barcodes. Otherwise, the United States Postal Service isn't going to deliver your ballots. There's another injunction already in place because there had been a rule completed since the time of this litigation. And so the Trump regime's mail ballot scheme is currently blocked. And that matter would be judiciable because there's been a final order. There's been litigation regarding and an injunction regarding the final order because the Trump regime did what we all thought they were going to do to try to implement this unlawful voting scheme. And so that then can now go to the Supreme Court. But at this point, even though the Supreme Court has overruled the lower courts and issued a stay to allow the executive order by the Trump regime to be implemented in the time that's elapsed, there's been an implementation as it relates to the mail-in ballot piece, which is I think the piece that concerns most. And that's blocked right now since the rule has been issued. Norm Eisen, a lawyer who I respect, he said the following: please don't overreact to the Supreme Court's decision on the contemplated USPS ballot moves. They simply held that the injunction came too early in the process before there was a final rule. Now we have a final rule and we will litigate it. Election security expert David Becker says there is another injunction in place, and even the majority of the court agreed that a new lawsuit could be appropriately filed after a final Postal Service rule was issued. In fact, the final Postal Service rule was issued late last week, though the court seems to be ignorant of that fact, or the Supreme Court doesn't mention in its 6-3 right-wing Supreme Court ruling. I expect that the states will file a new lawsuit and that this order will remain blocked for 2026. I think that is an important point because there is a lot of disinformation that this order will allow Donald Trump to now all of a sudden do all of his illegal voting tactics and prevent ballots from being sent to their destination. I don't want to take lightly that Trump is going to keep on trying to do that. And of course, we should be concerned about this Supreme Court ruling. And I think it's a very bad ruling, and I'll explain why as well. And we'll go through it in a little bit of technical detail. But I don't want to overstate the ruling that it somehow says what the Trump regime did is lawful and that the states don't have the rights to monitor their elections. No, it was simply done on judiciable and standing grounds. But let me give you this type of example. Imagine, give you a little bit of a violent example, but I think it brings home the point. Imagine somebody who shoots people with their gun and kills them, or causes serious grievous harm with their gun. Now holds up a gun to someone and says, I'm going to shoot them, or I'm going to shoot you. In 5 seconds, you're going to be shot. 5, 4, 3, 2, prepare to be shot. I'm going to shoot you. Then you go to a court and you go, hey, he's counting down 5, 4, 3, 2. They're going to shoot me. I don't want to be shot. Clearly, I'm in danger. I'm injured because the threat encroaches on my bodily autonomy. The threat is enough to cause me the injury. And the lower court and the higher court, the circuit court, basically says, yeah, we want to protect you. We're courts. We don't want you to have to wait to get shot or get hurt before you bring the lawsuit. There seems to be a real issue there. The Supreme Court steps in and basically says, nope, not judiciable yet. There's no injury until you actually get shot, until you're caused the pain. Then you can go and you can say, well, now it's illegal. Now it's unlawful. Now we've been treaded on. Remember the don't tread on me crowd? Don't tread on me with state rights. All this right-wing Trump regime, fascist regime does is tread on people. So that's the dynamic that we're dealing with right over here, is that the Supreme Court's saying it's premature. We don't have the ability to bring this case yet. And the states are saying, well, after we're already injured and we're hurt, there's going to be a lot of confusion that's going to be caused, and we're responsible for implementing our elections and our processes here. And if you're going to try to encroach upon our election processes, yeah, we can sue you afterwards and we could win, but this is going to cause us a lot of confusion at the state level. And the Supreme Court's like, well, deal with the confusion in a lawsuit. That's when you're injured. Don't bring the lawsuit now. So let's just take a look at it, because there was a scathing dissent as well from Justice Jackson. You had a less scathing dissent from Sotomayor and Kagan, but Jackson's dissent was absolutely scathing. So the Supreme Court sets out the following. They say, here's the 3 aspects of Trump's executive order. It says, first, it orders the Secretary of Homeland Security to take appropriate action to create and send state citizenship lists to each state. These lists will catalog the residents of each state who are U.S. citizens and who will be above the age of 18 at the time of an upcoming federal election. Now, the states say we have our lists. We don't need Donald Trump giving us, because Trump lies about everything and Trump's a fraudster. So obviously he's going to probably give us fake lists that kick off Democrats or that kick off people by he's going to say all these people are illegal when they're not illegal. And that's how Trump talks about things. Second, Trump's executive order required the Attorney General to prioritize the investigation and, as appropriate, the prosecution of state and local officials or any others who issue federal ballots to ineligible voters. Third, it directs the Postal Service to initiate a proposed rulemaking that includes several proposed provisions. One such provision is the outbound ballot envelope must contain a unique barcode to facilitate tracking. The order does not demand that any proposed provision appear in the final rule, and states are saying this is a states' rights issue. We do fine with mail ballots. We don't need Trump's incompetent postmaster general and the Trump regime getting involved in this and telling which ballots count or don't. Take our mail, deliver it to where it needs to go, and shut up. This is a states' rights issue. But the Supreme Court says, well, at this stage, this is the right-wing fascist Supreme Court. It was a 6-3 decision. They said, well, it's a proposed rule. The Postal Service didn't implement the rule yet. Yeah, the other section requires the Attorney General prioritize investigations, but there hasn't been an investigation yet. And the first part of the order says, Homeland Security, take appropriate action to start creating and sending the citizenship list over to the states. But it doesn't say the states have to use your citizenship list. But when you take the section of send over the citizenship list, with the other section that says you're going to be prosecuted if the Trump regime in their discretion believes you're not following their election processes, the states are saying, well, you seem to be basically saying you're going to prosecute us for not using your phony list versus our real lists that are kept with the state. And regarding the changes to the way the mail is happening, by the time you make your proposed order, no matter what your order is, it's always going to infringe on state rights. So the very fact that you're saying you're going to do an order that changes the way states handle mail, and the mail ballots, no matter what you came up with, it's going to be unlawful. So states are like, why would we need to wait for you to issue the rule when no matter what the rule is, it's going to be the equivalent of shooting us, basically, in the example that I gave before. In any event, the Postal Service did come up with its rule. There is an injunction regarding that rule, and that is blocked separately outside of this Supreme Court case. So that's why a lot of legal commentators are saying, as it relates to the upcoming election, it shouldn't change the way mail ballots are sent, and it shouldn't alter the way the midterms are. Now, in terms of what the impact could be after the midterms, if the Supreme Court were to stay the orders blocking the actual rule and allowing the federal government to create via executive order and not a law by Congress. By the way, if Congress passed a law that said certain things, that's different than an executive order. But if in the future, the Supreme Court was okay with this executive order changing the way states do their mail ballots, that would be a major issue. But we're not there yet. When you read the Supreme Court's decision, they seem to say the main issue with the current lawsuit is just its standing and justiciability issues. And so it's too early. It's not ripe yet to bring the case here. And so that's why a lot of people are saying as it relates to the midterms, this probably won't have a major impact. Justice Sotomayor and Justice Kagan, two of the liberal justices, say, today's decision does not address whether the president's attempts to interfere with the state administration of the November 2026 election are lawful, nor does it suggest that the executive branch has any constitutional or statutory authority to implement the president's directive. Instead, today's decision merely postpones adjudication of those challenges. Nonetheless, because I believe the respondent states' challenges are justiciable now, I respectfully dissent. And they say it's justiciable now because announcing the equivalent of what I said before. Announcing we're going to shoot you is an injury. Announcing we're going to tread on your state's rights is the injury. And a state can say, I'm not going to wait until I'm injured. You're telling me you're going to injure me. I need to block the injury before I get hurt. That's basically the argument there by Sotomayor and Kagan. Then you had Justice Jackson with a more powerful dissent saying, this ruling violates well-established precedents concerning this court's equitable discretion and needlessly injects chaos and uncertainty into the upcoming midterm elections. It also lets another shoe drop in the Kafkaesque nightmare that our precedents have been steadily creating for certain plaintiffs who seek to bring election-related challenges. The court has held for a while now that even valid election-related legal claims can come too late. Today's revelation is that such claims can also come too early. Never mind that an election is looming and related harms are presently occurring. Never mind, too, that the government, which controls the timing of proposed and final rules, can easily game the system. To be sure, the court has not foreclosed states from challenging this blatantly unconstitutional executive order, but it declines to explain when exactly is the right time to bring a meritorious election rule claim challenging unconstitutional interference with electoral processes. The majority just signals that these claimants had to wait, even though the election cycle had started, and despite facing pocketbook costs, threats of prosecution, and an affront to their sovereignty before receiving the relief to which they are likely entitled. I respectfully dissent. States administering elections and voting public that relies on them to do so deserve clarity, not caginess and confusion. The court does a disservice to all concerned by distorting Article 3 standing and ripeness principles to issue a ruling that contributes to pre-election chaos instead of quashing it, and by using its equitable authority to facilitate a patently inequitable result. And so I do see a lot of people kind of downplaying the impact of the ruling, and I understand why. But that's just as Jackson's still saying, there's going to be a lot of confusion that's caused to states. A lot of what do they do? How do they react? How do they respond to this? And so I think that's an important piece of this as well, that we don't necessarily exaggerate the impact of this ruling, but I also don't want to understate it like I'm seeing some people do as well. Don't worry about it. I think we got to worry. We have a right-wing fascist Supreme Court that is basically saying, states, wait until you get shot in the face before you have a claim. And then when you're injured, then bring a claim. And then there may be confusion because the Trump regime is going to say, well, we already have ordered the Postal Service to use our barcodes, not the state. So maybe we won't be able to deliver the mail, right? Think about where that argument can go. Hit subscribe. Let's get to 7 million subscribers. We're grateful for you. We appreciate you. Let's get to 7 million subscribers. Pre-order WTF America now. Thanks everybody for watching.
Before you go, our book, WTF America, is available for pre-order now. It's the story of how we got here and how we fight our way back. To pre-order, scan the QR code or click the link in the description. Let's do this.